Assalamu alaikum, dear students. I, Professor Said Guliamov, will be presenting today's lecture on Cyber Law, Lecture 5, Personal Data Protection in the Digital Age, Part 2. We'll investigate copyright in the digital age, software protection, and patenting in it. Get ready to explore the fascinating realm of AI-generated intellectual property and means of individualization in cyberspace. This lecture will challenge your understanding of intellectual property rights in the rapidly evolving digital landscape. Copyright in the digital age, new objects, usage models, and protection. Copyright in the digital age overview. The digital revolution has fundamentally transformed the landscape of copyright law, as our slide illustrates. Traditional concepts of intellectual property are being challenged, necessitating new approaches to protection and enforcement. As highlighted on the slide, international efforts have extended copyright protection into the digital realm, introducing novel concepts like the right of making available to the public. This evolution, noted in our overview, reflects a delicate balancing act between safeguarding creators' rights and ensuring public access to information and culture. The slide emphasizes how easy reproduction and distribution in the digital age challenge traditional notions of scarcity and control that have long underpinned copyright law. As we navigate this new terrain, copyright law must adapt to encompass new forms of creative expression, dissemination methods, and consumption patterns, ensuring its relevance in our rapidly evolving digital ecosystem. New objects of copyright protection. The digital age has ushered in a plethora of new objects demanding copyright protection, as our slide vividly illustrates. Software copyright, protection of websites and user interfaces, digital art, and non-fungible tokens are at the forefront of this new frontier. The slide highlights the EU Database Directive's extension of copyright-like protection to databases, showcasing the law's adaptability. A particularly intriguing point on our slide is the ongoing debate surrounding the copyright status of AI-generated works, which challenges our fundamental notions of authorship and creativity. Video games, as noted, present a unique challenge due to their multi-layered copyrightable elements. The slide also points to augmented and virtual reality technologies as introducing novel forms of creative expression, pushing the boundaries of existing copyright categories. This rapidly evolving landscape demands continuous adaptation of copyright law to address emerging creative forms in our digital world. Digital rights management and technological protection measures. Digital rights management systems and technological protection measures, as our slide emphasizes, have become crucial tools in the arsenal of copyright enforcement in the digital age. The slide highlights how international treaties and national laws prohibit the circumvention of these digital laws, reflecting their importance in protecting copyrighted works. However, as noted, there is a palpable tension between DRM and fair use, dealing particularly in areas like digital preservation and archiving. The widespread adoption of DRM in streaming services and e-books mentioned on the slide has ignited debates about consumer rights and the very concept of digital ownership. This complex landscape, as our slide suggests, calls for a balanced approach, one that protects copyright holders' interests while preserving user rights and fostering innovation in our digital ecosystem. Fair use and fair dealing in the digital context. The concepts of fair use and fair dealing have undergone a dramatic transformation in the digital age, as our slide illustrates. In the US, the fair use doctrine has been reinterpreted for digital technology, with the slide highlighting the expansion of transformative use to encompass large-scale digitization projects. The slide also notes how UK and Commonwealth jurisdictions have expanded fair dealing exceptions for digital uses. Digital sampling in music and user-generated content, as pointed out, pose new challenges for fair use analysis. The slide draws attention to the emerging discussions around fair use in text and data mining activities, reflecting the growing importance of computational analysis of copyrighted works. Lastly, the contentious role of fair use in software reverse engineering is highlighted, underscoring the ongoing efforts to balance copyright protection with technological innovation in our digital world. First sale doctrine and digital goods. The application of the first sale doctrine to digital goods, as our slide illustrates, has become a battleground in copyright law. The EU's use SOFTB Oracle case, highlighted on the slide, applied exhaustion to downloaded software, potentially opening the door for a secondary market in used software licenses. In stark contrast, the slide points to the US case Capitol Records v. Reed Diggy, which ruled against applying first sale to digital music files. This divergence, noted on our slide, underscores the challenges in adapting traditional concepts of ownership and control to the digital realm. The slide emphasizes how digital exhaustion remains a contentious issue, balancing consumer rights and secondary markets against copyright holders' interests. Libraries, as mentioned, face particular challenges with digital lending, as ebook licensing often restricts traditional lending practices. This complex landscape reflects the ongoing struggle to adapt copyright principles to our digital reality. Liability regime for online service providers. The liability regime for online service providers, as our slide illustrates, represents a crucial balancing act in digital copyright law. The US DMCA and EU e-commerce directive, highlighted on the slide, establish safe harbor provisions for OSPs meeting certain conditions. The notice and takedown system, while efficient, faces criticism for potential abuses, as noted. Our slide points to a significant development with Article 17 of the EU Copyright Directive, introducing new obligations for certain OSPs, including controversial upload filter requirements. This evolution, emphasized on the slide, reflects ongoing debates about balancing copyright enforcement with free expression online. The challenge, as our slide suggests, lies in creating a framework that protects copyright while fostering innovation and preserving the open nature of the Internet. This delicate balance continues to shape the evolving responsibilities of online platforms in our digital ecosystem. Peer-to-peer file sharing and copyright law. Peer-to-peer file sharing has profoundly challenged copyright law, as our slide vividly illustrates. Landmark cases like A&M Records v. Napster and MGM Studios v. Grokster, highlighted on the slide, have established crucial principles of liability for P2P service providers. The slide notes that the legal status of decentralized P2P technologies remains complex, reflecting the ongoing challenges in this area. Enforcement strategies, as mentioned, have evolved to include graduated response systems, though their effectiveness is debated. Our slide points out that ISPs face increasing pressure to combat P2P infringement, raising important questions about their responsibilities and network neutrality. These challenges, as the slide emphasizes, have catalyzed significant changes in copyright industry's business models, with streaming services emerging as a market-based response to widespread file sharing, reshaping the landscape of digital content distribution. New licensing models for digital content. The digital age has necessitated innovative licensing models, as our slide clearly illustrates. Creative Commons licenses, highlighted on the slide, offer flexible permissions while allowing creators to retain certain rights. Open source licenses like GPL, also mentioned, have fostered collaborative software development on an unprecedented scale. The slide emphasizes how streaming and subscription models are transforming digital distribution, raising profound questions about ownership and access in the digital realm. Our slide points to the EU's focus on facilitating cross-border licensing in the digital single market, reflecting the need for adaptable legal frameworks. The potential of blockchain and smart contracts in managing digital rights is noted, though widespread adoption faces challenges. These diverse licensing models, as our slide suggests, demonstrate the copyright system's adaptability, while highlighting the ongoing need for flexible legal frameworks in our rapidly evolving digital landscape. Digital preservation and orphan works. Digital preservation and orphan works present unique challenges in copyright law, as our slide vividly illustrates. Many jurisdictions, as noted, have introduced exceptions for preservation activities by libraries and archives, recognizing the cultural importance of digital heritage. The EU Orphan Works Directive, highlighted on the slide, establishes a framework for using works with unidentifiable rights holders, addressing a critical issue in digital preservation. Our slide points to landmark cases that have clarified fair use for digital preservation and library access, shaping the legal landscape. Web archiving and software preservation, as mentioned, pose complex copyright challenges that demand innovative solutions. The slide also emphasizes the intersection with data protection laws, adding another layer of complexity to digital preservation efforts. These multifaceted challenges underscore the need for adaptive copyright frameworks that balance preservation of cultural heritage with protection of creators' rights in the digital age. Adapting copyright law to the digital age. As we conclude, our slide emphasizes the ongoing challenge of adapting copyright law to the digital age. The need to reconcile territorial laws with global digital content, highlighted on the slide, necessitates international harmonization efforts. New licensing and business models, as noted, demonstrate the copyright system's adaptability, but also underscore the need for flexible legal frameworks. Our slide emphasizes the crucial importance of preserving copyright exceptions in the digital context to maintain the delicate balance between protection and access. The role of case law in interpreting copyright for digital works is highlighted, reflecting the dynamic nature of this field. As our slide concludes, the ongoing evolution of copyright law must strive for a balance that maintains incentives for creation while embracing the transformative potential of digital technologies, ensuring its relevance and effectiveness in our rapidly evolving digital world. Legal protection of software, regimes, registration, and licensing. Overview of software protection. In the digital age, software protection has evolved into a complex, multifaceted approach, as our slide vividly illustrates. The cornerstone of this protection, as highlighted, involves a blend of copyright, patent, trade secret, and sui generis regimes. The slide emphasizes the international consensus on copyright as the primary form of protection, enshrined in the WIPO Copyright Treaty and TRIPS Agreement. However, as noted, implementation varies significantly across jurisdictions, particularly in areas like software patentability and non-literal element protection. This diversity reflects the ongoing global dialogue on balancing innovation incentives with access to fundamental programming concepts. The slide underscores how the unique nature of software challenges traditional intellectual property paradigms. This complexity necessitates adaptive legal frameworks to address software's dual nature as both literary work and functional technology, a critical consideration in our rapidly evolving digital economy. Copyright protection for software. Copyright protection, as our slide emphasizes, forms the bedrock of software protection globally. Its appeal lies in the low barriers to protection and the long duration of rights it offers. The slide highlights how comprehensive protection for computer programs, including both source and object code, is enshrined in legislation like the US Copyright Act and EU Software Directive. Landmark cases, as noted, have played a crucial role in shaping the contours of this protection, addressing complex issues such as the idea-expression dichotomy and GUI protection. The slide points out a significant debate surrounding the duration of copyright protection, typically extending 70 years beyond the author's death, which some argue is excessive given the rapid pace of technological advancement. Despite these debates, copyright remains the primary means of software protection, striking a delicate balance between accessibility and long-term exclusivity rights in our digital landscape. Patent protection for software. Patent protection for software, as our slide illustrates, has undergone a significant evolution, reflecting ongoing debates over the appropriate scope for computer-implemented innovations. The slide highlights key U.S. cases: Diamond v. Deere, which opened doors for software patents, and Alice Corp. v. CLS Bank, which narrowed eligibility criteria. In contrast, the European approach, governed by the EPC, is noted as more restrictive, requiring software inventions to solve technical problems in a non-obvious manner. The slide emphasizes the ongoing challenges posed by business methods and AI algorithms in the realm of patentability. This evolving landscape, as our slide underscores, reflects the complex balancing act between protecting innovation and preventing overly broad patents that might stifle progress in the rapidly advancing field of software technology. The dynamic nature of this area continues to shape the future of software innovation and protection. Trade secret protection for software. Trade secret protection, as our slide demonstrates, plays a crucial complementary role in the software protection strategy, particularly for valuable, non-public components. The slide emphasizes the importance of non-disclosure agreements in preserving confidentiality, especially in development and licensing contexts. An interesting point highlighted is the challenge posed by the open source movement to trade secret protection, though companies have developed strategies to balance openness with proprietary protection. The slide also notes the significant risks posed by employee mobility, underscoring the need for careful management of access and confidentiality agreements. As our slide concludes, trade secret protection offers a flexible tool for safeguarding software innovations, particularly in rapidly evolving fields where other forms of protection might be less suitable or desirable. This adaptability makes trade secrets a vital component of comprehensive software protection strategies. Software protection registration procedures. Software protection registration procedures, as our slide illustrates, vary significantly depending on the type of intellectual property involved. The slide highlights that while copyright registration is not mandatory, it offers substantial benefits, including the ability to sue for infringement and potential statutory damages. An interesting point noted is the U.S. Copyright Office's allowance for redacted source code deposits, balancing protection with trade secret preservation. For patents, the slide emphasizes the complex disclosure requirement, necessitating a delicate balance between adequate description and avoiding overly broad claims. The slide also mentions trademark registration for software product names and logos, with the Madrid system offering centralized international protection. As our slide concludes, the choice of protection method often depends on the specific aspect of the software and overall business strategy, underscoring the need for a tailored approach in navigating these diverse registration procedures. Open source licensing. Open source licensing, as our slide vividly illustrates, has revolutionized software development, fostering unprecedented collaboration while preserving certain rights. The slide highlights the influential GNU General Public License, noting its copyleft provision that ensures derivative works maintain the same terms. An important legal milestone mentioned is the Jacobson v. Katzer case, which affirmed the enforceability of open source licenses. The slide points out the challenges posed by license compatibility, a critical consideration for developers working with multiple open source components. As our slide emphasizes, open source licensing has created a vast commons of freely available code, significantly impacting software development practices and business models. This paradigm shift in licensing and collaboration continues to shape the landscape of software development, fostering innovation while challenging traditional notions of intellectual property in the digital age. Proprietary software licensing. Proprietary software licensing, as our slide demonstrates, remains a dominant force in commercial software distribution, encompassing a diverse array of approaches tailored to different markets and deployment models. The slide highlights the importance of end-user license agreements in establishing usage terms, noting the legal precedent set by cases like Proc v. Zeidenberg in affirming the enforceability of electronic contracts. An interesting shift noted on the slide is the move from perpetual ownership to subscription access in software as a service model, introducing new legal frameworks. The slide also points out the complex jurisdictional issues introduced by cross-border licensing. As our slide concludes, proprietary licensing continues to evolve, striving to balance vendor control with user needs while adapting to new distribution and consumption models in our ever-changing digital ecosystem. Specialized licensing challenges. The landscape of software licensing, as our slide illustrates, is continually reshaped by emerging technologies and new business models. The slide highlights the unique challenges posed by mobile app licensing through platform-specific stores, creating new distribution paradigms. Game software licensing, as noted, grapples with the complexities of virtual economies, raising novel questions about virtual property rights. The slide points out the challenges in IoT device software licensing, particularly regarding update mechanisms and long-term support. An intriguing area highlighted is AI and machine learning licensing, which must address issues of training data ownership and autonomously generated outputs. The slide also mentions cloud computing, emphasizing the need for structured agreements on data segregation and service levels. These diverse scenarios underscore the pervasive nature of software in modern society and the ongoing need for adaptive licensing approaches to address emerging technologies and business models. Software license enforcement. Software license enforcement, as our slide demonstrates, involves a complex interplay of technical and legal mechanisms. The slide highlights how technical methods like activation systems provide an initial defense against unauthorized use. Legal actions for breach of license terms, as noted, have established important precedents, with cases like MDY Industries v. Blizzard Entertainment shaping the legal landscape. An interesting challenge pointed out on the slide is cross-jurisdictional enforcement, particularly relevant in the era of cloud services. The slide also mentions the use of audit rights in enterprise licenses to verify compliance, though noting the potential tensions this can create. As our slide concludes, the intersection with antitrust law is becoming increasingly prominent in software license enforcement. This multifaceted approach to enforcement reflects the ongoing challenges in protecting software developers' rights while ensuring fair use and competition in our digital marketplace. Future of software protection and licensing. As we look to the future of software protection and licensing, our slide emphasizes its critical role in the digital economy. The multifaceted approach to protection, as highlighted, reflects software's complex nature as both creative expression and functional technology. The slide notes that licensing models continue to evolve, adapting to technological and business changes. Challenges remain, as pointed out, in harmonizing international approaches, addressing emerging technologies, and ensuring fair competition. An important trend highlighted is the increasing focus on balancing proprietary rights with the benefits of open innovation. As our slide concludes, the future of software law will likely see refined application of IP concepts, new licensing models for emerging technologies, and an ongoing effort to balance innovation with protection. This evolution underscores the crucial role of effective legal frameworks in driving innovation, ensuring interoperability, and maintaining trust in our increasingly software-dependent world. Patenting in information technology, peculiarities and limitations. Overview of its patents. The realm of its patents, as our slide illustrates, encompasses a vast array of innovations in computing, software, and digital systems, constantly pushing the boundaries of traditional patent paradigms. The abstract nature of many innovations, highlighted on the slide, strains the very definition of patentable subject matter. Interestingly, as noted, patents in this field serve a dual purpose, both as defensive assets and as incentives for innovation. The slide emphasizes the gradual expansion of patentable subject matter in major jurisdictions like the US, EU, and Japan, punctuated by periods of recalibration. This evolution, as our slide points out, reflects the ongoing efforts to strike a delicate balance between protecting innovation and keeping abstract ideas in the public domain. The dynamic nature of this landscape underscores the unique challenges faced in patenting innovations, shaping the future of intellectual property in our digital age. Patentable subject matter in it. Determining patentable subject matter in it, as our slide vividly illustrates, is a complex endeavor fraught with challenges. The abstract nature of many innovations, highlighted on the slide, pushes the boundaries of what is traditionally considered patentable. Interestingly, as noted, while US law provides a broad definition, judicial interpretations have imposed significant limitations, especially for software and business methods. The slide contrasts this with a European approach, which explicitly excludes computer programs as such from patentability, yet has developed a nuanced approach focusing on technical character. A particularly intriguing point highlighted is the emergence of AI, machine learning, and blockchain technologies, which blur the lines between abstract methods and concrete applications. This evolving landscape, as our slide emphasizes, reflects the ongoing efforts to adapt patent law to rapidly evolving innovations, while maintaining fundamental patentability principles. Novelty and non-obviousness in its patents. Assessing novelty and non-obviousness in its patents, as our slide demonstrates, presents unique challenges due to the rapid pace of technological advancement and the prevalence of incremental innovation. The slide highlights the landmark case of KSR International Co. v. Califlex Inc., which emphasized the flexible approach to obviousness in the US. An intriguing point noted is the complexity of prior art assessment in it, given the diverse sources, including open source repositories. The concept of a person skilled in the art, as mentioned on the slide, plays a crucial role, yet varies significantly across different technological domains. The slide also points out the impact of open source development on novelty considerations and the strategic use of defensive publications. These factors collectively underscore the need for adaptive approaches in evaluating patent applications within the context of our rapidly evolving technological landscape. Drafting patent applications. Drafting patent applications, as our slide illustrates, requires a delicate balance between technical precision and legal breadth. The slide emphasizes the challenges faced in functional claiming, noting the limitations and the need for specific structural descriptions. An interesting point highlighted is the crucial role of detailed descriptions, flowcharts, and diagrams in supporting claims and enabling implementation. The slide mentions the relevance of means plus function claims, while cautioning about the need for careful drafting. A particularly intriguing aspect noted is the growing importance of strategies for covering both hardware and software implementations. This multifaceted approach to drafting, as our slide suggests, reflects the complex nature of innovations and the need for patent applications that can capture their essence while meeting the stringent legal requirements for clarity, support, and enablement in our rapidly evolving technological landscape. Standard essential patents in it. Standard essential patents, as our slide vividly illustrates, play a critical role in the sector, particularly in telecommunications and networking. The slide highlights the concept of FRAND licensing, which aims to balance the rights of patent holders with the need for widespread adoption of standardized technologies. Key legal cases like Huawei v. ZTE and FTC v. Qualcomm, mentioned on the slide, have significantly shaped this landscape. An intriguing point noted is the prominent intersection of SEPs with antitrust law, reflecting concerns about potential market power abuse. The slide also emphasizes the expanding role of standards-dependent technologies in the IoT era, necessitating adaptive licensing models. This complex interplay between standardization, innovation protection, and fair competition, as our slide suggests, continues to shape the evolving landscape of patents and technological progress. Non-practicing entities in it. Non-practicing entities, as our slide illustrates, have significantly impacted the sector, sparking intense debates about the balance between patent rights and innovation. The slide highlights the America Invents Act introduction of measures to curb abusive litigation, including post-grant review procedures. A landmark case mentioned is eBay v. Merck Exchange, which established a four-factor test for injunctive relief, fundamentally altering NPE strategies. The slide notes the evolution of defensive strategies, including the emergence of patent aggregators and cross-licensing agreements. Recent Supreme Court decisions, as highlighted, have further shaped the NPE litigation landscape. This complex interplay between NPEs, legislative reform, and judicial decisions, as our slide suggests, reflects the ongoing efforts to address the role of NPEs in the patent system, striving to balance innovation protection with the prevention of abusive practices in our dynamic sector. Open source software and patents. The intersection of open source software and patents, as our slide demonstrates, presents a fascinating landscape of legal and philosophical considerations. The slide highlights the concept of patent commons and pledges, designed to protect open source projects from patent aggression. An intriguing point noted is how major open source licenses include provisions specifically addressing patent issues. The slide emphasizes the importance of patent compliance in open source development, necessitating careful tracking of contributions. A particularly interesting aspect mentioned is the significant impact of open source on prior art considerations in patent examinations. This complex interaction between traditional patent protection and collaborative, open development models, as our slide suggests, continues to shape the evolving relationship between intellectual property rights and open innovation in the sector, reflecting the ongoing adaptation of legal frameworks to new modes of technological development. AI and machine learning patenting. AI and machine learning patenting, as our slide vividly illustrates, presents a new frontier of challenges in the realm of intellectual property. The slide highlights the novel issues in subject matter eligibility that these technologies introduce. A particularly intriguing point noted is the debate on AI inventorship, exemplified by the DAB-US patent applications, which challenge traditional notions of inventorship. The slide emphasizes the delicate balance required in describing AI algorithms in patents, weighing the need for detail against preserving competitive advantage. An interesting aspect mentioned is the intersection of AI patents with data protection laws, adding another layer of complexity. The slide also points out the ongoing AI patent arms race among tech giants. This rapidly evolving landscape, as our slide suggests, underscores the need for adaptive patent frameworks capable of addressing the unique characteristics of AI innovations while maintaining fundamental patent principles. International considerations in it patenting. International considerations in it patenting, as our slide illustrates, play a crucial role in the global tech industry. The slide highlights the Patent Cooperation Treaty's role in streamlining multi-country patent applications, while noting the significant differences in patentability criteria across jurisdictions. An intriguing point emphasized is the jurisdictional challenges in enforcing patents for cloud-based inventions. The slide notes the increasing importance of Asian markets, particularly China, in global patent strategies. A fascinating aspect mentioned is the challenge of patent translation for inventions due to their technical complexity. The slide concludes by highlighting the need for successful global strategies that combine PCT filings, strategic national entries, and tailored approaches for different markets. This complex international landscape, as our slide suggests, underscores the need for a nuanced, global perspective in its patenting strategies, reflecting the borderless nature of technological innovation. Future of it patenting. As we look to the future of it patenting, our slide paints a picture of a landscape filled with unique challenges and opportunities. The slide emphasizes how the dynamic nature of the IT sector continually pushes the boundaries of traditional patent concepts. A particularly intriguing point noted is the introduction of new dimensions by AI and machine learning, challenging long-held patent principles. The slide highlights the growing importance of international cooperation in innovation, while acknowledging the challenges posed by divergent national approaches. An interesting aspect mentioned is the adoption of multifaceted IP strategies by companies, combining patents with open innovation and trade secrets. As our slide concludes, the future of it patenting will likely see ongoing refinements in legal doctrines, examination practices, and international harmonization, aiming to foster groundbreaking innovations while preserving the collaborative spirit that drives technological progress in our interconnected digital world. Intellectual property generated by artificial intelligence, issues of authorship and ownership. Introduction to AI-generated intellectual property. In the realm of intellectual property, AI-generated creations are pushing the boundaries of traditional notions, as our slide vividly illustrates. The challenge to conventional ideas of authorship, ownership, and creativity is profound. As highlighted, WIPO has recognized the global nature of these challenges, initiating a worldwide dialogue on IP and AI. The slide emphasizes the diverse forms of AI-generated IP, from text and images to music and inventions, each presenting unique legal hurdles. Notably, as pointed out, the legal status of AI-generated IP remains in flux across major jurisdictions like the US, EU, UK, and China. This uncertainty, as our slide suggests, will significantly shape innovation policy and creative industries in the coming years. The evolving nature of AI systems, as emphasized, continues to raise critical questions about authorship, ownership, and appropriate IP protection, underscoring the need for adaptive legal frameworks in our digital age. Copyright law and AI-generated works. Copyright law's approach to AI-generated works, as our slide illustrates, varies significantly across jurisdictions, reflecting broader philosophical differences about authorship and creativity. The US stance, highlighted on the slide, requires human authorship, effectively excluding works produced solely by machines. In stark contrast, the UK's approach, as noted, provides copyright protection for computer-generated works, defining the author as the person arranging the work's creation. An intriguing point emphasized is the challenge posed by the concept of originality for AI-generated works, traditionally rooted in human creativity. The slide also highlights the potential for joint authorship between humans and AI systems, raising questions about the extent of human creative input required for copyright eligibility. As our slide concludes, even the duration of copyright for AI-generated works may differ from standard terms, underlining the complex adaptations needed in copyright law for AI-generated content. AI-generated inventions and patent law. AI-generated inventions, as our slide demonstrates, are challenging the very foundations of patent law. The slide highlights how major patent offices like the USPTO and EPO have rejected applications naming AI systems as sole inventors, reaffirming the requirement for human inventors. This stance, as noted, underscores the tension between traditional patent concepts and the growing capabilities of AI in invention processes. An intriguing point emphasized is the complexity introduced to the person skilled in the art standard when assessing non-obviousness for AI-generated inventions. The slide also points out the significant economic impact of decisions regarding AI inventorship. As highlighted, proponents argue it could incentivize AI innovation, while critics warn of potential patent thickets and diminished human inventive activity. This debate, as our slide suggests, reflects the ongoing struggle to adapt patent law to the realities of AI-driven innovation. AI-generated brands and trademark law. The intersection of AI-generated brands and trademark law, as our slide illustrates, presents a fascinating new frontier in intellectual property. While the slide notes that USPTO guidelines don't explicitly address AI-generated brands, it emphasizes that fundamental requirements of distinctiveness and use in commerce still apply. An intriguing challenge highlighted is establishing distinctiveness for AI-generated brands, particularly if they're based on existing market trends. The slide points out the potential for AI to inadvertently generate infringing marks, raising complex liability questions. An interesting development noted is AI's expanding role in trademark searching and clearance, offering efficiency, but also raising concerns about over-enforcement. The slide concludes by highlighting the added complexity when AI-generated marks intersect with geographical indications and cultural symbols, underscoring the need for cultural sensitivity and adherence to local regulations in this evolving landscape of AI-generated trademarks. Trade secret protection for AI systems. Trade secret protection, as our slide illustrates, offers a valuable avenue for safeguarding AI systems, algorithms, and outputs. The slide emphasizes the challenges in maintaining secrecy during collaborative AI development, highlighting the need for careful information management. An intriguing point raised is the question of how to classify AI outputs as trade secrets when they're generated by autonomous systems. The slide also notes the strategic decisions required when balancing trade secret and patent protection for AI innovations. An important consideration highlighted is the risk posed by employee mobility to AI trade secrets. This multifaceted approach to protecting AI through trade secrets, as our slide suggests, reflects the complex nature of AI development and deployment. The flexibility of trade secret protection, as emphasized, makes it a particularly attractive option for safeguarding AI innovations, especially in rapidly evolving fields where patent protection might be challenging or undesirable. Ownership and assignment of AI-generated IP. The ownership and assignment of AI-generated IP, as our slide vividly illustrates, present a complex landscape of legal challenges. The slide highlights the potential application of the work made for hire doctrine to attribute ownership to the entity commissioning the AI, though its applicability remains untested. Various ownership models are noted, including AI developer, user, or joint ownership, reflecting the diverse perspectives on this issue. An intriguing point raised is the complication introduced by open-source AI models in determining ownership. The slide emphasizes the crucial role of contractual agreement in commercial contexts for determining ownership. A fascinating possibility highlighted is the potential for AI-generated works to enter the public domain directly, potentially expanding the pool of freely available creative works. This complex interplay of ownership concept, as our slide suggests, underscores the need to adapt traditional IP frameworks to the unique nature of AI-generated content, moral rights, and AI-generated works. The application of moral rights to AI-generated works, as our slide illustrates, challenges fundamental assumptions about creative expression. The slide highlights how the Berne Convention and French law frame moral rights in terms of human authorship, creating a tension with AI-generated content. An intriguing point raised is the question of attribution rights for AI works, which challenges our notions of creative identity and origin representation. The slide also notes the practical challenges in applying integrity rights to AI outputs, particularly in objecting to modifications. A fascinating aspect highlighted is AI's potential to infringe upon human authors' moral rights, introducing new dimensions to this debate. The slide concludes by emphasizing the novel challenges presented by the intersection of moral rights with data protection laws in AI context, underscoring the need to balance creative rights with privacy concerns in our evolving digital landscape. AI-generated works and IP infringement. AI-generated works and IP infringement, as our slide illustrates, introduce a new realm of complexity in liability and enforcement. The slide highlights the potential need to reevaluate the concept of innocent infringement, as AI-generated content challenges traditional notions of culpability. An intriguing point raised is the potential need to adopt fair use doctrines for AI-generated works. The slide emphasizes the technical challenges in detecting infringement in AI-generated content, potentially necessitating sophisticated recognition technologies. A significant concern highlighted is AI's potential for mass infringement, presenting unprecedented challenges for rights holders and enforcement agencies. The slide concludes by noting that potential defenses in AI infringement cases may reshape IP litigation. This evolving landscape, as our slide suggests, underscores the need to adapt infringement concepts and enforcement mechanisms to the realities of AI-generated content in our digital age. International approaches to AI-generated IP. The international landscape of AI-generated IP, as our slide illustrates, reflects a diverse array of approaches and challenges. The slide highlights WIPO's efforts to foster dialogue among member states on these complex issues. Notable points include the EU's coordinated plan addressing IP implications in its AI strategy, and the emphasis placed by China and Japan on IP protection in fostering AI innovation. An intriguing aspect highlighted is the unique challenges faced by developing countries in balancing AI participation with concerns about technological gaps. The slide also raises the fascinating possibility of AI havens emerging, potentially introducing new dynamics in the global innovation landscape. This diverse international approach, as our slide suggests, underscores the need for collaborative, global strategies in governing AI-generated IP, reflecting the interconnected nature of our digital world and the borderless potential of AI innovation. Future considerations for AI-generated IP. As we look to the future of AI-generated IP, our slide paints a picture of both challenge and opportunity. The slide emphasizes the critical need for legal frameworks to evolve, accommodating AI while preserving core IP principles. An intriguing point raised is the necessity for interdisciplinary collaboration in addressing these complex challenges. The slide highlights the importance of considering ethical implications, including accountability and the potential displacement of human creativity, alongside legal and economic factors. A key emphasis is placed on the crucial role of international cooperation in developing harmonized approaches to govern AI-generated works across borders. As our slide concludes, well-designed IP policies for AI-generated works will be paramount in harnessing AI's potential while addressing its unique challenges, ultimately shaping the future of innovation in our digital age. This evolving landscape promises to redefine the boundaries of creativity, authorship, and ownership in the AI era. Means of individualization in cyberspace, domain names, meta tags, keywords. Introduction to digital identifiers. In the vast landscape of cyberspace, digital identifiers have emerged as the cornerstones of online identity and brand recognition. as our slide illustrates, domain names, meta tags, and keywords play a crucial role in online branding and e-commerce. The slide highlights the key roles of WIPO and ICANN in governing these identifiers, particularly through domain name dispute resolution. Interestingly, as noted, the evolution of these digital identifiers mirrors the broader development of the Internet ecosystem. The slide emphasizes the varying legal status of these identifiers among major jurisdictions like the US, EU, and China, reflecting diverse approaches to balancing IP protection with fostering digital innovation and free speech. This complex interplay between technology, law, and commerce, as our slide suggests, underscores the dynamic nature of cyberspace and the ongoing challenges in regulating online identities. Domain names and intellectual property. Domain names, as our slide vividly illustrates, sit at the intersection of technical infrastructure and intellectual property law. The slide highlights ICANN's role in governing domain name allocation and management, while the DNS translates human-readable domains into IP addresses. A key point emphasized is the U.S. Anti-Cybersquatting Consumer Protection Act, which combats bad faith domain registrations infringing trademarks. The slide notes the potential conflict between the first come, first served registration principle and trademark holders' rights. An intriguing aspect highlighted is the concept of bad faith registration, encompassing practices like cybersquatting and typosquatting. The slide concludes by mentioning landmark cases like Spotty's Farm v. Sportsman's Market, which have shaped the legal landscape, establishing crucial precedents for interpreting bad faith and legitimate interest in domain registrations. This complex framework, as our slide suggests, reflects the ongoing challenge of balancing efficient domain allocation with trademark protection in cyberspace. Uniform Domain Name Dispute Resolution Policy. The UDRP, as our slide demonstrates, stands as the primary mechanism for resolving domain name disputes in cyberspace. This streamlined process, highlighted on the slide, offers trademark holders a powerful tool to challenge potentially infringing domain registrations. The slide emphasizes key decisions like Yahoo Inc. v. Akash Arara, which have established critical principles for assessing bad faith and confusing similarity. An intriguing aspect noted is the concept of reverse domain name hijacking, which safeguards against abusive complaints. The slide also points out the complexities introduced by new GTLDs, expanding the domain space and creating new challenges for trademark protection. This system, as our slide concludes, strikes a delicate balance between global consistency and national specificity in resolving domain-related intellectual property conflict, reflecting the intricate nature of cyberspace governance. Meta tags and legal significance. Meta tags, as our slide illustrates, have undergone a fascinating evolution in their legal significance, mirroring changes in SEO relevance. The slide highlights the landmark case of Brookfield Communications v. West Coast Entertainment, which established the initial interest confusion doctrine for digital context. An intriguing point noted is the legal distinction between visible and invisible meta tags. The slide emphasizes the complex intersection of trademark law and fair use in meta tag context, particularly for descriptive or nominative use. This evolution, as our slide suggests, vividly reflects the dynamic interplay between technological changes and legal interpretations in digital trademark protection. The ongoing adaptation of legal frameworks to the rapidly changing landscape of search engine optimization and digital marketing underscores the challenges in protecting intellectual property rights in cyberspace. Keyword advertising and trademark law. Keyword advertising, as our slide vividly illustrates, has become a central battleground in digital trademark law. The slide highlights Google's AdWords policy, which attempts to balance the interests of trademark holders, advertisers, and consumers. A key point emphasized is the legal debate exemplified by cases like Rescuecom v. Google over whether keyword sales constitute use in commerce under the Lanham Act. The slide notes the continued importance of consumer confusion in legal assessment, with courts recognizing the growing sophistication of Internet users. This complex landscape, as our slide suggests, highlights the intricate balance between trademark protection, fair competition, and evolving digital advertising practices. The challenge of applying traditional trademark principles to the dynamic world of online advertising underscores the need for adaptive legal frameworks in cyberspace. Social media usernames as brand assets. Social media usernames, as our slide demonstrates, have emerged as critical brand assets in the digital age, governed by platform-specific policies. The slide highlights cases like La Raza v. Twitter, which underscore the challenges in applying traditional trademark principles to these new digital contexts. An intriguing point noted is the parallel between username squatting and cyber squatting, prompting platforms to develop policies against bad faith registrations. The slide emphasizes the added dimension of verified accounts in dispute, influencing assessment of consumer confusion. This evolving landscape, as our slide suggests, reflects the need to adapt trademark protection strategies to the unique characteristics of social media environments. The intersection of brand protection, personal identity, and platform governance in social media usernames exemplifies the complex challenges of intellectual property rights in cyberspace. Hashtag and trademark law. Hashtags, as our slide illustrates, have blurred the lines between brand assets and user-generated content, presenting unique challenges in trademark law. The slide highlights the USPTO's recognition of hashtags as potential trademarks, provided they serve source identifying functions. A key case mentioned is Exuzen v. Albanese, which has shaped the legal landscape around hashtag disputes. The slide emphasizes the complex intersection of hashtags with fair use doctrine, raising intricate legal questions. This evolving area of law, as our slide suggests, vividly demonstrates the ongoing adaptation of trademark principles to new forms of digital expression and brand engagement. The challenge of balancing brand protection with the dynamic, user-driven nature of hashtags underscores the need for flexible legal frameworks in the rapidly evolving digital landscape. Mobile app names and icons protection. Mobile app names and icons, as our slide demonstrates, represent a complex intersection of trademark law, copyright, and platform governance. The slide emphasizes that App Store policies often exceed traditional trademark standards, creating a unique legal landscape. An intriguing point noted is the overlap between copyright and trademark law in protecting app icons. The slide highlights the necessity for multi-jurisdictional strategies in global app distribution, reflecting the borderless nature of digital marketplaces. This multifaceted approach to protection, as our slide suggests, vividly illustrates the challenges of safeguarding digital identifiers in the rapidly evolving mobile app ecosystem. The need to navigate both legal requirements and platform-specific policies underscores the complexity of intellectual property protection in the mobile digital space. Geographical indications in digital spaces. Geographical indications in digital spaces, as our slide illustrates, present unique challenges in the global online marketplace. The slide highlights the WIPO Geneva Act, which provides an international framework for GI protection. A key case mentioned is Comite Interprofessional du Vin de Champagne v. Vickers, underscoring the challenges of protecting regional designations in the global domain system. The slide emphasizes the complex issues arising from GI use in meta tags and keywords, which often transcend jurisdictional boundaries. An intriguing point noted is the potential conflict between GIS and geographic GTLDs. This intersection of traditional identifiers with digital spaces, as our slide suggests, vividly demonstrates the complexities of protecting cultural and regional identities in the global digital marketplace, reflecting the ongoing challenge of adapting traditional IP concepts to the digital realm. Future of digital identifier protection. As we look to the future of digital identifier protection, our slide paints a picture of complex challenges and evolving solutions. The slide emphasizes the delicate balance required between brand protection, innovation, and free expression in cyberspace. A key point highlighted is the tension between territorial trademark rights and the inherently global nature of the Internet. The slide notes the increasing importance of self-regulation and industry practices in rapidly evolving digital environments. An intriguing aspect mentioned is the potential of alternative dispute resolution mechanisms to offer efficient conflict resolution. As our slide concludes, the future of digital identifier protection will require legal frameworks to evolve in tandem with the digital landscape, continually adapting to govern these essential elements of online identity and commerce. This dynamic interplay between law, technology, and commerce will shape the future of intellectual property rights in cyberspace. Thank you for attention.